He looked at me like I was furniture, not disrespect, worse than that. The kind of look that doesn't even register another person as a threat. I've seen defendants cry, I've seen them beg, I've seen men dissolve completely the moment they sit down in my courtroom. This one sat down like he owned the room, adjusted his cufflinks, leaned back, and before the prosecution had asked a single question, before we had even properly begun, he smiled at the gallery like this was all arranged in advance, and he already knew how it ended. I've been on this bench for 26 years. I know performance when I see it, and I know something else. The difference between a man who is confident and a man who believes he is protected. Confidence can be shaken. Protection, when it's real, cannot. The question that morning was, which one was he? His name was Marcus Drell, CEO of a financial services firm that had, according to the prosecution, systematically defrauded over 400 investors across 11 states over a period of 6 years. 400 families, retirement accounts, college funds, medical savings, 6 years of structured lies. The indictment was 47 pages long. The evidence log ran to 3 volumes. 3 federal prosecutors had prepared for 18 months to stand in my courtroom and dismantle this man. He arrived with 7 attorneys. 7. Not because he needed 7 to defend himself. He needed 7 to make sure nobody else in the room could move faster than his legal team. I understood it immediately. He wasn't here to answer questions. He was here to occupy the oxygen, to make the trial so procedurally expensive, so interrupted, so technically dense that the truth would drown in the process. It was a strategy. And for the first hour of that trial, it worked. The lead prosecutor, a woman named Claire Ashton, methodical, precise, the kind of lawyer who has memorized every document in the room, stood and began her opening. She was 20 seconds in when the first interruption came. One of Drell's attorneys, the senior man, a silver-haired litigator named Farrow, was on his feet before she'd finished her 3rd sentence. Objection, characterization. I looked at him. Overruled. Sit down, counselor. He sat. 30 seconds later, up again. Objection, speculation. Overruled. 40 seconds. Up again. Objection, foundation. I let a pause sit in the air long enough that the entire gallery felt it. Mr. Farrow, you will sit down and you will remain seated until it is your turn to speak. Are we clear? He sat. He did not look embarrassed. Neither did Drell. If anything, Drell looked slightly more entertained. The interruptions weren't random. Every time Ashton approached a specific category of evidence, wire transfers, internal communications, a particular set of accounts in the 2019 fiscal year, Farrow was on his feet. The pattern was deliberate. They weren't trying to win the objections. They were trying to train the jury. Every interruption told the jury, this area is contested. This area is dangerous. Look away. I let it run for 40 minutes, not because I was passive, because I needed to see the shape of it. Every chess player shows you their strategy in the opening. I was watching. Then Ashton moved to the first major evidence presentation, an internal spreadsheet, third-party audited, reconciled against bank records across 2 institutions. The kind of document that doesn't lie, because it can't. The numbers are pulled from systems that don't belong to anyone in the room. Before she could present it, Farrow was standing, but this time he didn't object. He moved, formally with a prepared motion, to have the document excluded on chain of custody grounds. The motion was 16 pages long. It had been pre-drafted. I looked at it. I looked at the timestamp on the filing. It had been submitted at 8:47 that morning. 43 minutes before proceedings began. They had prepared this before they heard how Ashton intended to use it. They knew what was coming. They had prepared a procedural wall in advance. I set the motion face down on the bench and said nothing. Ashton pivoted. Smoothly, without breaking stride, she moved to a second exhibit, a series of wire transfer confirmations, cross-referenced with investor account activity. Tight documentation, airtight. A second motion appeared, also pre-drafted, also time-stamped before the trial began. I looked at Drell. He had not moved. He was looking at his hands, not worried, patient, like a man who had placed something in motion a long time ago and was now simply watching it execute. That was the first time I understood what he meant when he said, later, what he said. Because everything I was watching, the motions, the interruptions, the witness who was about to take the stand and not say what she was originally going to say. It wasn't improvised defense. It was architecture. Somebody had spent months designing a machine inside my courtroom, and for the first 2 hours of that trial, the machine was running. Ashton called her first witness, a former CFO named Patricia Renault, a woman who had worked inside Drell's organization for 4 years before cooperating with federal investigators. Her original deposition was detailed, specific, and corroborating. She had documented conversations. She had contemporaneous notes. She had been prepared by the prosecution for 11 weeks. She sat down in the witness box. She smoothed her jacket. She looked at the jury, and then she said, "I want to clarify something about my prior statement." The room shifted. Not dramatically, no gasps, just a subtle change in air pressure. Ashton didn't move. She watched. Renault said, "When I described the communications between myself and Mr. Drell regarding the quarterly reports, I was characterizing them based on my interpretation at the time. I want to be clear that the directives I received were ambiguous. I cannot now say with certainty that Mr. Drell intended." Ashton was already moving. "Ms. Renault, I'm going to stop you there. Were you present at the meeting on March 14, 2019? I was. And were you present when Mr. Drell gave specific instructions regarding how investor losses would be reported to the board?" A pause. "I was in the room, yes." "And what were those instructions?" Another pause. Longer this time. I may have mischaracterized the nature of those instructions in my prior. I'm not asking about characterization. I'm asking what he said, in that room, on that day." Renault looked down. "I'd need to review my notes." I watched Farrow from the corner of my eye. He was leaning back in his chair, arms folded, doing nothing, because he didn't need to do anything. Whatever conversation had happened between Saturday evening and Tuesday morning, between when this trial was scheduled and when it began, had already done its work. I made a note, one word. I wrote it at the top of my legal pad and underlined it twice. Prepared. Everything in that room was too prepared. The motions, the retraction, the rhythm of the interruptions. It had the precision of something rehearsed. And Drell was the conductor. He hadn't needed to say a word all morning. He had walked into my courtroom and pressed play. The lunch recess gave the prosecution a window to regroup. Ashton spent it at the table, head down, her team cycling through alternatives. When we resumed, she adjusted her approach, moved to a different category of evidence, tried to establish foundation through a secondary document trail before returning to the primary. It was tactically sound, and for about 20 minutes it worked. Then she called Drell to the stand. He came up like a man attending a dinner party, relaxed, unhurried, settled into the chair with the particular ease of someone who has been professionally coached to appear professionally uncoached. His tie was straightened. His expression was open, attentive, faintly amused. Ashton began with basic biographical questions. She was not easing him in. She was walking the jury through a sequence. Every question was a brick. The wall would come later. Drell understood this and answered everything with the same cooperative mildness. Nothing to grab onto, nothing to challenge. Just smooth, calibrated replies that gave her no friction. Then she shifted. "Mr. Drell, were you responsible for communications to investors regarding fund performance in the years 2018 through 2021? Ultimately, yes. My team managed those communications. Your team, did you personally review those communications before they were distributed? I reviewed high-level summaries. High-level summaries, not the communications themselves. We were operating at significant scale. I relied on my team too. I'm asking if you personally read the investor letters before they were sent. A beat. Not always. But sometimes. Sometimes, yes. Mr. Drell, did you read the investor letter dated September 3, 2019? Farrow was half out of his chair. Ashton didn't wait. She had already moved to the document. Already had it on the screen. September 3, 2019. A one-page letter to investors. Standard quarterly communication. Projections, performance summaries, reassurances. Yes or no, Mr. Drell? Did you read this letter? I'd need to review the record. It has your electronic signature. The room held. Drell looked at the letter. Then yes, I reviewed it. It states in the third paragraph that the fund returned a positive 12% in Q3 of that year. Correct. Mr. Drell, did the fund return 12% in Q3 of 2019? He looked at her with the same measured patience. To the best of my knowledge, the figures were accurate at the time of... Did the fund return 12%? Yes or no? The methodology used to calculate, the fund lost 9%. Is that accurate? Farrow was on his feet. Objection. Assumes facts not in evidence. Counsel is overruled. I said it before he finished. The witness will answer the question. Drell adjusted in his seat, just slightly. There were multiple calculation methods in use at the time, depending on which method. There is one method, Mr. Drell, the one required by the SEC, and by that method, the fund lost 9%. Now, did you know that when you signed this letter? A pause that stretched 3 seconds, maybe 4. I believe I was operating on the figures provided by my team. Ashton didn't respond to that. She let it sit, let the jury hear it again in the silence. Then she moved. This is where something changed. Her junior co-counsel, a young lawyer named Daniel Marsh, second chair, the kind of presence who had not spoken once all day, passed a note down the table. Ashton read it, looked up at Drell. Then she said something unexpected. She passed the question to Marsh. I watched Drell. The shift was microscopic, a slight recalibration. He had been watching Ashton all day, learning her rhythm, anticipating her pattern. Marsh was an unknown quantity, and Drell knew it in that second, because for the first time he looked directly at me rather than the questioner. Marsh stood. He had the quiet energy of someone who had been waiting a long time. He didn't carry theatrics. He moved to the podium and said simply, Mr. Drell, you've said several times today that your team managed communications and you reviewed summaries. I want to ask you about one specific communication, not to investors, an internal one. Farrow was up. Objection. Scope. Overruled. I watched Drell. Marsh continued. Are you familiar with an internal messaging system your firm used during the period 2018 to 2021, a platform called Arbor? Yes. Did you use it? I did. Did your messages on that platform reflect your actual thinking about the fund's performance? Farrow. Objection. Vague. Overruled. The second time I said it that afternoon to the same attorney, the word landed with weight that didn't need explanation. Drell looked at Marsh with new attention. My messages reflected my communications with my team. That's not what I asked. I asked if they reflected your actual thinking. Yes, I communicated honestly with my team. Marsh nodded. Slowly. So, if a message sent by you to your CFO said something, that would be an honest representation of your understanding at that time? Generally, yes. Not generally. You just said you communicated honestly with your team. Yes or no? Do your Arbor messages reflect honest communication? A pause. Yes. Thank you. Marsh reached down. He didn't announce what he was reaching for. He didn't pause for effect. He simply placed a printed exhibit on the overhead projector and said, This is an Arbor message sent from your account, Mr. Drell, to Patricia Renaud on August 29, 2019. 5 days before the investor letter was distributed, the message appeared on the screen. It was 9 words long, 9 words, in plain text. No headers, no context, no formatting. Just 9 words that Marcus Drell had typed on a Thursday afternoon 4 years ago and sent to his CFO. Don't send the real numbers. We'll fix it in the letter. The courtroom did not erupt. Nothing dramatic happened in the first 5 seconds, because what happened was quieter than that and more permanent. The jury read it, the gallery read it, the senior partner at the defense table read it, and Drell read it. And for the first time since he had walked into my courtroom that morning, the expression on his face was not amusement. His attorneys moved fast. Farrow was on his feet. Objection. Your Honor, the authentication of this document has not been established. The chain of custody for communications from this platform has been, as we argued in pretrial motions, deeply flawed. This document should not be on screen. The jury should be instructed to disregard. Sit down. I said those 2 words with my full voice, not loud, controlled. The kind of voice that has 26 years behind it and does not need volume. Farrow sat. I looked at Drell. He was looking at the message on the screen. His hands were on the table. He had been leaning back all day. He was not leaning back anymore. Marsh said quietly, Mr. Drell, is this message from your Arbor account? My attorneys have raised serious questions about the authentication of. That's not an answer. Is this message from your account? The metadata on these files has been disputed in. I'm asking you a yes or no question, sir. Your account, your name at the top, 5 days before the letter that you signed went out. Did you write this? Drell looked at Farrow. Farrow looked at me. I looked at Drell. Answer the question. He straightened in his chair, and something crossed his face. something that was not quite calculation and not quite panic, but lived in the territory between them. He was running a decision tree in real time. Deny it, and the metadata would prove he was lying. Acknowledge it, and every answer he'd given in the preceding 2 hours became perjury. He said, "That message represents a miscommunication between myself and..." It says, "We'll fix it in the letter." Does that message reflect your honest communication with your team? Drell looked at me again. I said nothing. This was not a moment for the bench to intervene. This was a moment for a man to answer for his own words. "I need to consult with counsel before..." "You are under oath." Marsh's voice was flat. "You testified, under oath, 10 minutes ago, that your communications with your team were honest. This is one of those communications. Does it reflect your honest thinking on August 29, 2019? If he said yes, he had just confessed to instructing his CFO to falsify the investor letter. If he said no, he had just confessed to lying under oath 5 minutes earlier. There was no third option. The room understood this. I could feel it. The shift from spectacle to something more serious. This was not theater anymore. Drell said, "You have no idea what you're looking at." Marsh tilted his head, just slightly. "Then explain it." Drell looked at me. Not at Marsh, at me, and what I saw in his face at that moment was not the arrogance from the morning. It was something I have seen across this bench more times than I can count, and it never looks the same twice. It was the face of a man who has believed for a very long time that the rules apply to everyone except him, and who has just discovered, at some cost, that he was wrong. He looked at me and he said, softly, without volume, with a steadiness that I think surprised even himself, "You can't touch me. I have people. This doesn't..." "Stop!" "One word." I said it once. The room froze. I held the silence for a count of 5, long enough that every person in that gallery felt the weight of what had just been said in my courtroom, under oath, on the federal record. A man had just told a sitting federal judge, with a 9-word message on the screen behind him, while under oath, in an active criminal proceeding, that he was untouchable. I set down my pen. I did not raise my voice. "I am halting this proceeding." The murmur that came from the gallery was immediate. Farrow was on his feet before I had finished the sentence. 2 of the other defense attorneys reached for their briefcases simultaneously. The court reporter looked up. I spoke again, and I want you to understand that every word I used in that moment was chosen precisely because the record reflects everything and the record does not forget. "I am halting this proceeding, pending an immediate review of the testimony given today, the communications pattern exhibited by defense counsel, the authenticity certification of the newly introduced exhibit, and a statement made by the defendant directly to this bench, which has been captured in its entirety by the court record." I looked at Farrow. "Counsel for the defense will remain available. The defendant will not leave this building, and if anyone in this room believes that what just happened carries no consequence, I invite them to review the federal statutes on witness intimidation and obstruction of judicial proceedings at their earliest opportunity." I did not slam a gavel. I don't need theater. I stood. The bailiff called the room to order, and I walked to my chambers. I want to tell you what I thought about in those first minutes after I closed that door. I thought about the 400 families, the retirement accounts that had been deliberately hollowed out, the college funds that had stopped compounding, the medical savings that had been signed over to a structure designed, from the beginning, to enrich one man at the expense of every person who trusted him. I thought about how many of those people had watched the news that morning, wondering if today was finally the day, and I thought about that message. 9 words. Not because it was extraordinary. It wasn't. I have seen worse. I have seen documents that made this one look mild. What stayed with me was its casualness, the complete absence of any concern that it would ever be read by anyone who mattered. That is what impunity looks like, up close. It doesn't look like villainy. It looks like a man typing 9 words on a Thursday afternoon and pressing send without a second thought, because he had never once imagined a world where anyone would hold him accountable. He had that world. For 6 years, he had it. Then he came into mine. Let me tell you what followed. And pay attention here, because this is the part they don't show you. The drama ends with the gavel. What comes after is slower, quieter, and in some ways more devastating. The proceeding I halted that afternoon was never simply resumed, it was reconstructed. My order triggered an emergency review by the Federal Oversight Panel, standard procedure when judicial process has been potentially compromised at multiple levels. What that review found over the following 6 weeks was not entirely what anyone expected. The pre-drafted motions, time-stamped before trial, indicated advanced knowledge of prosecution strategy. That knowledge had a source. 2 sources, eventually, a paralegal inside the prosecution team and a former federal investigator who had been retained as a private consultant by Drell's firm. Both were indicted separately. The Arbor message Marsh had produced was the single piece of evidence that had slipped through the wall. It had been recovered from a backup server that Drell's legal team had missed during their evidence suppression effort because it was classified under a different project code. A backup server, a different project code, 6 years of fraud, 400 victims, 7 attorneys, pre-drafted motions, a corrupted witness, a compromised source inside the prosecution. And the entire architecture came down because of a categorization error in a file system. That is how these things end. Not with a dramatic confrontation, with a detail somebody forgot to clean up. Drell was convicted on 14 counts, including securities fraud, wire fraud, and obstruction of justice. The obstruction charge was in part due to what he said in my courtroom that afternoon. "You can't touch me," which the record captured cleanly, and which his attorneys tried, in post-trial motions, to characterize as an expression of frustration rather than an act of intimidation. I denied the motion. An expression of frustration does not require a man to look directly at a federal judge. Patricia Renault, the witness who had retracted her statement that morning, ultimately re-cooperated with prosecutors when it became clear that the protection she had been offered by Drell's network had evaporated. Her original deposition was restored, its contents corroborated, and she testified at length during the reconvened proceeding. She was not charged. Her testimony added 3 additional counts to the conviction. Farrow, the silver-haired senior partner who had stood up in my courtroom 19 times in a single morning, is currently the subject of a Bar Association disciplinary review. I have nothing further to add on that matter now, and I want to speak to you directly for a moment. Because you watched this expecting one thing, and you got something else. You came for the moment where justice arrives with weight and sound, and I gave you that moment. But I want you to sit with the other part, the part that comes before it. 400 families waited 6 years. That is not a minor number. That is not an abstraction. 6 years is a child finishing elementary school. 6 years is a savings account that was supposed to grow and didn't. 6 years is the distance between a diagnosis and a treatment that couldn't be afforded. While Marcus Drell adjusted his cufflinks and typed 9 casual words and leaned back in chairs and smiled at galleries, real people with real names watched real money disappear and wondered if anyone was paying attention. The answer eventually was yes, but eventually is a long time. I think about that every time someone sits in my courtroom and believes they are untouchable. And I want to be precise about what untouchable actually means. It doesn't mean powerful. It doesn't mean wealthy. It doesn't mean having the right lawyers, the right motions, the right network. Those things can be disrupted. Those things can be dismantled. I have watched them come apart in this room more times than I can count. Untouchable means not having anything you've said or done that a motivated attorney with a backup server can find. Drell was not untouchable. He was just surrounded by people whose job it was to make him look that way. Here is what I know from 26 years on this bench. Every single document that was ever written still exists somewhere. Every message sent in the belief it would never be read is sitting in a server, a backup, a forwarded thread, a printed attachment in a file nobody has opened yet. The infrastructure of dishonesty is enormous, and the people who build it never clean it up completely because they never believed it would be necessary. That is the gap. That is always the gap. A junior lawyer noticed a hesitation, passed a note, pulled a document. 9 words. The rest followed. The question isn't whether the truth is there. It almost always is. The question is whether anyone in the room cares enough, is skilled enough, is patient enough to find it and hold it up at exactly the right moment. When a man is already on the record, already committed to an answer he cannot take back, already in the chair. That morning someone was. Marcus Drell walked into my courtroom like a man who owned it. He left it in the custody of the United States Marshal. The shift between those 2 moments was not gradual. There was no long arc of justice slowly bending. There was a note passed across a table. There was a message on a screen. There was a man who finally ran out of things to say. And there was a bench that was watching the whole time. I've been asked, since this case concluded, whether I was surprised by what happened in that room, whether any of it caught me off guard. The answer is no, I was surprised by none of it. Not the interruptions, not the retraction, not the pre-drafted motions, not the network of corruption underneath, not even the arrogance, especially not that. Men like Marcus Drell are not rare. They are not exceptional. They are not uniquely brilliant or uniquely dangerous. They are simply men who have been told yes for long enough that they have forgotten the sound of no. What surprised me, and I will be honest because this bench demands honesty, was how quickly it ended once it started. The machine he had built was expensive and detailed and ran for 6 years, and it ran perfectly, right until the moment a single junior lawyer asked a follow-up question that wasn't in anyone's script. Then it was over in 4 minutes. That is the other thing I know from 26 years. These structures, the fraud, the cover, the network, the architecture of protection, they are not as strong as they look. They look impenetrable from the outside. From where I sit, they look like what they are. Weight-bearing walls built on a foundation that someone somewhere left incomplete. You find the incomplete part. You apply pressure there, and then you stop the whole thing. That is what happened in this case. That is what I ordered that afternoon. And that is ultimately what I am here to do. The 400 families received notification of the conviction 38 months after this trial began. Restitution proceedings are ongoing. Not all of them will be made whole. That is a truth I carry with more weight than the verdict itself, because justice in a courtroom is real, and it matters, and it means something, but it does not reverse time. What it does is this. It closes the door on what was happening. It stops the machine. It tells the next person watching from wherever they're watching, the next man about to type 9 words and press send, that this door exists, that this bench exists, that this moment where a man says, "You can't touch me," and discovers in real time exactly what that costs, is not a hypothetical. It happened. It is on the record. It will always be on the record. I put my pen down every day at the end of session. I lock my chambers. I walk out of the building, and the record remains. That is the thing about courts of law, that the people who try to manipulate them never fully understand. They focus on the lawyer, the motion, the witness, the ruling. They think in terms of individual obstacles to be managed and controlled. They don't think about the record. They don't think about the fact that everything said in this room, every word, every answer, every evasion, every 9-word message put on a screen, is transcribed, dated, certified, and stored. Permanently, not because I ordered it, because that is what courts do, because that is what the law requires, because somewhere, a long time ago, someone decided that power should be accountable to the written record of what it actually said and did. That person was right. Marcus Drell found that out on a Tuesday in October, in my courtroom, in the 4th row from the back, in a chair he had expected to leave without consequence. He did not leave without consequence, and neither will the next one.